Hiring a foreign national to work for your Canadian business could require a work permit. Melodie Hughes, a lawyer at Bomza Law Group, talked to Canadian HR Reporter TV about when a work permit is required versus when someone can enter Canada without requiring one at all.
It really does depend on a number of factors, including what the individual is coming into Canada to do. Generally speaking, a work permit is always required in Canada. There are, however, limited exceptions under Canada's immigration laws and regulations that enable someone to come into Canada to engage in business activities without requiring a work permit. In order to do so, however, the individual must maintain their primary place of residence outside of Canada. Their primary place of employment must continue to be outside of Canada as well. Some key things to keep in mind. Is the individual going to be placed on Canadian payroll? If that's the case, then automatically a work permit is needed. Also, something to keep in mind, the nature of the activities that the individual is coming in to do is very, very important. If the individual is engaging in activities that could be deemed to be competitive with those that Canadians currently engage and are paid to do in Canada, then a work permit would also be needed. As a general rule, and if in doubt, get a work permit.
Hughes says employers can be proactive if they're considering hiring a foreign worker.
First and foremost, I recommend that every company establish a corporate immigration policy. Or if you already have an existing global mobility program or relocation program, establish a policy that can be incorporated into that. Not only will an immigration policy clearly outline where the responsibilities lie in the immigration process, who's responsible for doing what, but it also will outline the procedures and the processes to follow to ensure that there are clear lines of communication. If there is any instance of potential non-compliance or non-compliance, employers know where to go, what to do. Something else to keep in mind, education is very, very important. Not only do HR managers need to know and understand immigration compliance, but more and more business managers, site managers are being brought into the fold. Anyone who has any idea or any say in terms of the who, what, where, and when of a foreign national's employment, they should be educated so that they understand the implications of any key business decisions impacting a foreign worker's work.
Employers need to proceed with caution because there are liabilities.
They can be vast and varied. Some of the potential penalties of noncompliance can include fines for the company that can be quite significant, up to $100,000 in some instances. Also, the company can be subject to a compliance review, and if you're found non-compliant with that, then you could be subject to a 2-year ban from hiring any foreign workers. That's pretty significant. In addition, reputational damage. Your name could be placed on what we're calling a blacklist, notifying the entire public that you are a non-compliant employer. Most companies don't like that.